You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention. You shall be heard. God save these United States, great state of Florida, this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Welcome to the Florida Supreme Court. The first case on our docket today is McCoy versus State of Florida. You may proceed.
Good morning, y'all. My name's Dave Collins. I'm from Monticello, Florida. I'm here on behalf of Mr. McCoy, and I'm arguing for him. This is a tough case. This is a tough case. These are tough facts that Mr. Chipperfield had to encounter, and I've got to try to convince you all that he was not only ineffective, but it had an effect on the outcome of the case. That's that simple. That's where everything's viewed through. All right? And so I've got to somehow substitute my thinking for his thinking. We had a audio taped, somewhat of a lying confession that was made. We had fingerprints on a bank bag receipt. You know, and we had a defendant testify that should never have probably testified from a tactical decision. But how, as a lawyer, do you keep a defendant from testifying if he wants to?
Well, when there is the problem with the fingerprints on the bank bag, and there's some need for how do you explain it? I mean, he came up with an explanation. I don't think anybody thought it was very credible, but it was an explanation of how that would give a reason for his fingerprints being on the bank bag. Now, I understand there was some challenge about the fingerprints separate from that, but isn't that a reason for him to have testified? I mean, it's not fanciful. I mean, what he said may be fanciful, but the fact that he would make a choice to testify to explain it. Otherwise, you've got this very damning fact that is just there and is uncontested.
Well, in response, you had a choice, maybe a Hobson's choice. His explanation was unbelievable. It was offensive. And it might have changed it from a 7-5 death penalty vote to a 6-6 if they didn't believe he was a liar. No one believed that. No one believed that. So
but now, did the lawyer really know what the defendant was going to say once he got on the stand? I mean, wasn't that somewhat of a surprise to him?
I don't think the record lets us know either way.
Either way, okay.
It doesn't let us know either way. So if we're going to nitpick at Mr. Chipperfield now, the choice is put a guy on that's going to tell such an outlandish story you're not going to believe him and remove any doubt, or put your fingerprint expert on and say, well, these fingerprints were just fingertip prints and the eighth or whatever. You don't know what these juries are going to believe. You just never know. But to put him on.
Let me ask you this. The defense is alibi, correct?
It's alibi insufficiency of the evidence.
Well, but used someplace else. Was there any other way, were there any other witnesses that could have been called to say he was someplace else other than the defendant?
Well, by elimination there was. There was a gentleman in the parking lot outside the liquor store by the name of Victor Williams, who during that time period, if called, would have testified that he neither saw the defendant there or his vehicle. And
but both those. Now, come on. Isn't the evidence indicate that he saw this at the front door and that she actually came in the back door? Isn't that the way the testimony came out here? So that he was not in a position to see the back door.
That's correct.
Okay.
That's the best we have, Judge.
Well, but I think Justice LaBarca asked you about alibi. Was there any other witnesses that could have been called for alibi?
There were technically two. One was his mother, and one was his mother's friend, Diana Peterson. Okay? But they had the dates messed up.
But that was an alibi about whether or not he told someone else about this at that time, right? As opposed to an alibi for where he was at the time that the actual event took place? Yes,
ma'am. Diana Peterson was, and his mother was, but his mother also would have been an alibi witness. No, you're correct. You're correct. I'm thinking of his girlfriend, Dorothy Small, who was called, I believe, as a witness.
Well, you're very forthright on this, and it does appear, having looked at the whole transcript of the evidentiary hearing, that Mr. Chipperfield, he did the best making reasonable decisions. Now, you could say now, looking at it, well, we would have made different decisions. On the other hand, you could say 7-5 is pretty amazing considering the crime, and so we're speculating. And it seems to me that on the one that you started with, whether trial counsel was ineffective for failure to advise McCoy of the dangers of testifying, on that, the judge found that McCoy was told by his counsel and also there's a little bit of a colloquy before he testifies about what would come up. But unlike other cases where a defendant insists on testifying against the advice, here Mr. Chipperfield said, with the statement that he made to the girlfriend, this was a calculated risk. Isn't that, I mean, that's what Chipperfield said. So we would have to say that that is, under every set of circumstances, an unreasonable trial strategy. And I'm not, when you've got he was recorded saying something to the girlfriend about this, so his explanation that he wanted to show that he was just as tough as she was, I mean, maybe it's absurd, but it's all he had.
Well, Your Honor, with all due respect to Mr. Chipperfield, that recording in and of itself could have helped him because it says someone else was there with him. That could have segued into the argument that the other person was the shooter. When you put him on the stand and he testifies now, nobody believes him. You have a recording, okay, that says someone else might have been the shooter.
But wouldn't that be in conflict with the alibi defense? I mean, the alibi, I wasn't there, so therefore, how do you make that argument?
I
told you
the whole
fact.
The whole business of calling a defendant, a criminal defendant, to stand, not call him. Criminal defense lawyers will argue back and forth on that. I've heard from some that said you start with the proposition that you call them, but for a darn good reason. And some others you don't call them, but for a good reason. So it's a matter of strategy. Here, it just seems to me that the counsel had an alibis and self-defense are the type of things that you have to start out with the proposition that the defendant needs to explain it. So you start out with that. I don't know that this was an unreasonable decision. He worked with what he had. If alibi was going to be the defense, and there were no witnesses who would testify that he was at a dance hall dancing with someone at the time, how else but to put him on the stand would you prove alibi?
Your Honor, quite honestly, I see what you're saying, and I think this is just not a very strong issue for the defense. I mean, you can't. I went through the record and picked out what I could. I think I'm better off arguing the cumulative effect of all this stuff.
Okay.
Because I see this case as 7-5, a 7-5 death decision. And all murders are heinous. They're all heinous. And certainly this one was. But I've played out triple murder cases before to life with much more heinous facts than this one.
But unless you can show deficiency with respect to more than one thing, you don't get to the issue of cumulative effect. I mean, you might, if you got deficiency but not enough prejudice on one, add the prejudice up. But where's I don't see the deficiency in any of it. So I don't know how you get the analysis.
Well, the deficiency is this case should have not been a death penalty case. I know you're like, what are you saying, Mr. Collins?
Whose fault? I mean, you can't fault the trial attorney for that. I mean, whether to proceed on any case and seek the death penalty really is a function of the state attorney's office. They look at the facts, they look at the history, and they make that determination as to whether or not they're going to seek it. And unless you can tell us that there's some other information here that the defense attorney did not present to the jury or to the judge that would have negated the aggravating fact or would have demonstrated that it was more powerful than the aggravating factor, what is the defense attorney to do?
That's correct. But this, putting him on the stand or him making the decision to take the stand, from my experience, and this is all second guessing, might have been the deciding point that made that jury really not like him. That fanciful story was ridiculous. If they don't know.
Well, but the problem here, this really is not a very defensible case. So any path you take is likely assault. And as to this not being a death case, I don't know why it's not a death case.
Well, it is.
It turned out to be a death case, but I don't. I mean, it doesn't strike me as kind of on the fringe of what ought to be a death case. I mean, this kind of execution carried out in the course of a robbery, we got all kind of death cases like that. This is not a robbery gone bad in the sense of some struggle or something like that. There's no evidence of that. Right. So the notion that this is an outlier for a death case, I don't accept that premise.
I understand. I've tried almost 20 murder cases. It's my opinion this shouldn't have been a death case. I understand.
But you, I mean,
it doesn't matter.
But you're not arguing even proportionality here.
No.
So I mean, it's
not it wasn't the subject of a 3851. I mean, no more than the ring issue. But I have to put it in. If I don't, you have a case like Evans. I don't know what courts are going to do, you know. But this case, it's a tough case. The issues of failing to object to religious references, I don't know. You know.
The what? Religious
Issue 2.
Oh, okay.
I look at that. It's in there because Mr. Chipperfield said he should have probably objected to it, but I don't know.
What do they do in Monticello?
What's that?
I mean, it seems to me, religion. I mean, all he said was God-given common sense. It's hardly the kind of reference to religion that we roundly condemn, whether it should not be said anyway, but that's certainly not a fundamental error, is it?
No.
You are in your rebuttal time.
All right. Thank you.
May it please the Court? Assistant Attorney General Charmaine Millsaps. I'm going to talk about the issue 4 as well. Ineffectiveness for not advising McCoy of the dangers of testifying in his own behalf. I would like to get it straight that the trial court here made a credibility finding that Chipperfield, who was more credible than the defendant, and Alan Chipperfield, who is a well-known to this court, who has extensive capital experience, who also had co-counsel, testified that it is his standard practice. He could not remember this particular case, but that it is his standard practice in capital cases to discuss testifying with his client multiple occasions. So that testimony was found to be credible.
Now, there's one part where you say, listen, if you take the stand, you will be cross-examined on your prior violent felonies or your felonies.
The trial court warned the defendant of that.
That
on
is
the
well.
record.
But as I understand it, Chipperfield wasn't telling him, my advice is for you not to testify. So you're testifying against my advice. He thought, based on this case and the facts and the conversation with the girlfriend, that was not an unreasonable decision. Is that correct?
No.
In other words, did he? Well, let me ask you: did he, the defendant, testify against Chipperfield's advice that he shouldn't testify?
Chipperfield testified that he does not advise his clients, to testify or not to testify. And let's get something straight.
Well, that doesn't make any sense. I mean, the defense lawyer is there and says, it's up to you. You could go on or not go on?
No, what he does is he tells them the pros and cons.
Well, in this case,
he wants them to make the informed decision.
In this case, wasn't his recommendation there were more pros than cons? I mean, in other words, we have a lot of cases where these defendants get on the stand and they sink their case because they just say everything. I thought that in this case, the defense lawyer felt that was a reasonable strategy for Mr. McCoy to testify.
Your Honor, what he said was there were certain advantages. For example, this was going to be an alibi defense. Sherry Cross, a neighbor, had testified in the defense case that she was at 8 o'clock in the morning outside taking out her garbage and had a 5 or 6 minute conversation with McCoy, with the defendant here. And so Chipperfield was, in an alibi case, it is normally a good idea to put the
Well, that's
defendant...
what I'm asking you. This is a friendly question. Why are you making it so difficult?
I'm telling you what he testified to.
Well, you don't
Honor.
have... Do we think in a capital case that a defense lawyer would say, hey, man, it's up to you. Here are the pros, here's the cons, but you make the decision? He gives advice. Doesn't he give advice? Didn't he give advice in this situation that it would not be, that although there are cons, there are also pros, so that he was not against him testifying?
He was not against him testifying, absolutely.
Wasn't
What he was explaining was the pros and cons.
Well, wasn't a part of his strategy having something to do with the woman who testified that he had confessed to her of his involvement? Wasn't there something about her being involved in a robbery also, and then the trial judge saying, I'm not going to let this on unless the defendant first says that she confessed to him about some other robbery?
And McCoy
was that a part of the whole strategy of putting him on the stand?
Zsa Marcel, one of the things that we were going to do was impeach Zsa Marcel with the Lee's chicken robbery. And the trial court had ruled, and McCoy testified at the evidentiary hearing. The reason he testified was because of this trial court ruling, and the trial court had ruled that I will not let you do this until you establish, you may not do it on cross during the state's case of Zsa Marcel. But if there is evidence in your case, you may recall Zsa Marcel.
Well, he's telling that to McCoy, but isn't that something that Chipperfield took into consideration as far as advising the defendant?
Well, yeah, I mean, Your Honor, he told him all the different pros and cons. But, Your Honor, you have to recognize the law. The law is defendants have an absolute right to testify and not to testify. This is not defense counsel's decision. This is personal, and the United States Supreme Court has held this is one of the 4 areas that is absolutely personal to the defendant.
But that doesn't preclude counsel from saying, my advice to you is to testify or to not testify. That's not
true.
precluded.
No, Your Honor, absolutely.
Well, the point you're making, I think, is that this counsel decided he would give the pros and cons, but without making a recommendation as to whether he should testify. He might weigh one way or the other based on the pros and cons, but he would not give the bottom line recommendation.
Right, and I think that is not deficient performance.
That
is perfectly reasonable.
It was also a colloquy, wasn't there, between the trial court and the defendant in this case?
Before his testimony, the trial judge, Judge Deering, told McCoy, you have an absolute right to testify and an absolute right not to testify. But I do want to warn you about impeachment with your priors. The trial court said that.
What he said actually said, and I quote it, and you have been advised of the consequences of testifying. Being cross-examined about prior felony convictions and the like.
And the like.
Yes, sir, I have. And are you satisfied that all those things in balance, that's in your best interest to testify in this case? The boy says, for the truth to come out, yes, sir. So there was a colloquy with the court.
There was an on-the-record colloquy where McCoy basically tested. The implication of that, Your Honor, the clear implication of that is that he and Chipperfield had discussed this. Now, by discussing it, Chipperfield is a highly experienced capital litigator, and because in recognition that there is this right, that is his policy. He does not make a bottom line recommendation. He tells them, look, here are the advantages, here are the disadvantages.
Isn't what Chipperfield asked, what he explained was, listen, you have an alibi defense.
You do.
Now, have an alibi defense, you probably need to testify now.
It helps.
That needs to be explained now. And we also have this fingerprints on so that needs to be explained.
And it's going to be a problem for us,
there'd be a problem,
unquote.
precisely. So
yes. So clearly what went on was a detailed discussion about both it is good for you to support this alibi, Sherry Cross, the neighbor, and So what? Now, he couldn't remember all the details, but it's very clear that a detailed conversation occurred in the context of this case. The advantage would be you would support the alibi. And we have a big problem with the fingerprints. The option of putting on and that's the other thing. Chipperfield testified that the defendant, by telling this story, and he directly testified, it was a surprise to me. All right? So I disagree with counsel as far as that goes. At the evidentiary hearing, Chipperfield testified that this story about the bag being found in the parking lot on Roosevelt Avenue, the ABC bag, was a surprise to him.
What did he expect? I mean, if one of the strategies was you need to explain how your fingerprint got on this bag, what did he expect him to say? If what he said was a surprise, what did he expect him to say about how his fingerprint got there?
Well, there was no testimony, but I can answer that. He expected him to say those fingerprints are not mine, because that was how he was going to deal with the fingerprints. And the cross-examination... He was going to say, in the face of an expert who said that was his fingerprint, he was going to say that wasn't his fingerprint? Because Chipperfield had cross-examined the expert about partials. You cannot really tell. These were partial fingerprints. There were 3 partials on the ABC receipt bag, plastic bag. And this is what Chipperfield's strategy. He did testify. This was my strategy for dealing with the fingerprints. And McCoy undermined that strategy with his testimony. He wanted and he did cross the fingerprint examiner, that partials are not full fingerprints are unique to a human being, but that there's no scientific evidence that partials are unique to a human being. So what he was really expecting McCoy to do, if he took the stand, was to say, those are not my fingerprints. That's what he was expecting.
In properly advising a client whether to testify or not, isn't that something counsel should have known meeting with his client before going in there and making this decision? I mean, it sounds to me like what you're saying is that the defense counsel was completely shocked as to what came out of the defendant's mouth. He didn't know what the defendant was going to say?
That's what he said. He thought his testimony was that the story, not every part of the defendant's testimony, the big picture that he was talking to Sherry Cross at the time to establish the alibi, he knew about that large parts of the testimony that he thought was going to come out, yes, he knew about those. What he didn't know was this defendant was basically going to lie about the 2 months before. That part he didn't know. What he really expected him to say was, these are not my fingerprints.
Who asked the question of the defendant? Are these your fingerprints? Was it on cross-examination or direct examination?
It was on cross.
And so did he discuss with the defendant, what are you going to say when you're asked about the fingerprints?
He was not asked that at the evidentiary hearing, but he did testify.
I mean, you would agree that if he didn't discuss with his client an issue about it's going to come up, these are your fingerprints, that would be clearly deficient performance.
We're getting something confused. It's not that he didn't say you're going to be crossed on the fingerprints. Okay? What the part that's new was what McCoy was said back. Okay? No, they absolutely did have a conversation, and Chipperfield testified that the fingerprints are a big problem in this case, and we need to do something about that. That he was told that he was going to be crossed about fingerprints is very much in this record.
Right,
okay?
but the question then, see, if Mr. Chipperfield is meeting with his client, holding cell, the night before testimony or whatever, and the defense counsel is going to tell his client this fingerprint business is what's going to make or break the case here. You got your fingerprints on this pouch, and there's no reason for you having those fingerprints on there. How are you going to explain that? And the defendant tells him one thing in the holding cell or in the cell the night before. And the next day, he takes a stand and says something else. That's another thing. But for Mr. Chipperfield to just say to him, the fingerprint thing is a major problem, and just leave it at that, see what he's going to come up with.
Okay.
Understand? That's deficient.
And what do we have if you do it your way? Nix versus Whiteside.
And no, what he said was it can help to try and give an explanation why the prints are there. It seems to me as if he would have known, but what will the explanation be? I mean, he can't tell him to lie, to fabricate a story, but he can ask him, what are you going to say? And then he can say, well, I believe you, but I don't think a jury would believe that.
and then he has a problem under Nix versus Whiteside. What we're really doing is this. If the defendant tells him this story, he's in the exact same position the lawyer in Nix versus Whiteside was. That's exactly what happened in Nix versus Whiteside. His client told him that never mentioned ever seeing a gun. And then the night before trial, probably in the holding cell, says, I'm going to say I saw something metallic. And the lawyer says, oh, no, you're not. And if you do, I'm going to withdraw and tell the judge that you're committing perjury. And that went out all the way to the United States Supreme Court. And the United States Supreme Court said prejudice may not be premised on perjury. Understand the position that Chipperfield would have been in the exact same position that the lawyer in Nix versus Whiteside was. Worse.
So you're saying that a lawyer, I mean, I've done a lot of these cases. I mean, you always ask the client, when you're talking to him, okay, when I put you on the stand tomorrow, and I ask you, how did this fingerprint end up on this pouch? What are you going to say? I mean, I'm going to ask that question. He's going to tell me what he's going to say. And that'll make a determination on my part as to whether I recommend that he take the stand or not. Because if he told me, I'm going to say that I found this pouch 2 weeks ago and I picked it up to look at it, I'm going to tell him, listen, I'm advising you not to take the stand with that. But if he said something else that was reasonable, and then he takes a stand and said he found it, makes this thing up, then that's a surprise. I can understand that. But you always ask the client what he's going to say.
And next day when he does take the stand and tells the story about the pouch, as is his right to do, what do you do then? You're in the Nix versus Whiteside situation. Understand, this is rather a common practice among the defense bar.
Aren't we really engaging in pure speculation in this discussion? This is not developed in this record, is it?
It is not.
I mean, we don't know.
We do not know. We did not. What we did was just the claim that was really litigated was, did you have a discussion? And Chipperfield basically said, yes, I always have discussions with my client, especially in capital cases. Did you have one in this case? Well, I can't remember because my file's missing as usual. But that is my standard practice. Chipperfield was not asked, okay.
That's the extent of, wait a minute, that's the extent of the discussion.
That
so
really
that's the record that we have to work with.
That's the record that you have to work with. And that's why I'm not trying to hide anything from this court.
No, I'm not suggesting that. I'm trying to get so that we know the record that we're working with to either affirm this or send it back. And that's what I'm trying to understand.
And that's why I'm trying to, there is basically a hole in this record. That kind of particular question about what did you specifically say about the fingerprints? Now, he did mention that he told the defendant that the fingerprints are a big problem. But he was never asked, okay, and then what did the defendant tell you? And what did you advise him regarding telling the story? None of that was gotten into, Your Honor. There is a great, this is very speculative, because that was not, the claim litigated down below was much broader, was just a general claim of did you advise him? And when Alan Chipperfield said yes, and what's more is we had this colloquy on the record with the trial judge, that really ended it down below. So we did not really litigate in the kind of detail that we are talking about here.
Did the defense have a fingerprint expert?
Yes, Your Honor, in the sense he consulted with two fingerprint experts. Alan Chipperfield testified at the evidentiary hearing, I consulted with two fingerprint experts that were different from the state. He then decided one of the fingerprint experts that he consulted verified that these were McCoy's fingerprints. So one of them did say that they were McCoy's fingerprints.
But nevertheless, the strategy was to put him on and have him testify that those were not his fingerprints?
Because his strategy that I think he got from the other, Your Honor, we also didn't nail that down, but the other expert that he consulted was the one that he got I think the partial theory from. I'm going to call it the partial theory, that you cannot really, the identification of partials is, and this is true, the identification of partials is nowhere near as scientifically strong as full fingerprints.
And that theory had nothing to do with facts that this defendant could provide one way or another.
No, Your Honor, really.
Right.
That was, but the idea that he was somehow ineffective in dealing with these fingerprints, I mean, that's just off the table. He consulted not one but two fingerprint experts, which obviously he cannot call the one who verifies it, and he gets this he does enough background and does a pretty good job of cross-examining the expert about partials. You know, that partials are not the same as full fingerprints.
And so, you could talk about calling this other individual as being deficient performance, but that was not challenged in this case.
No, Your Honor. They did not say, okay, and then instead of crossing the state's expert, you should have called I'm going to call him the second fingerprint expert. None of that, and that's why I can't tell you exactly what I just know from what Chipperfield's cross of the state's fingerprint expert, that seems to be where he got. But there would be absolutely no deficient performance on the fingerprints. You can't do more than consult two experts. He's done everything you can at that point.
Well, I mean, you could criticize that he should have placed one of the experts on.
But no such claim was made.
Well, I understand, but, I mean, to say that you can't criticize, you could, but it's not an issue in this case.
I don't think you could ever find deficient performance when a lawyer has consulted two other experts.
We won't go there. It's not an issue in this case. It's a friendly question, and
okay.
So I can see you don't want to
I would
accept
like
it
to
as
talk
is.
just a minute about cumulative error. For there to be cumulative error on ineffectiveness, you would have to find two deficiencies before you could even accumulate. And the state asks you to affirm the trial court's order denying the post-conviction motion, and thank you for your time.
Rebuttal?
When we talk about Mr. Chipperfield and criticizing him, I was thinking of one of the suggestions that Justice Perry made about an explanation for these fingerprints. He had an explanation for these fingerprints. It was on the audio recording that Zaza Marcel had that said he was an accomplice, that said he was there but he was not the shooter. That was his way out from the death penalty. You understand? You don't put him on there and he tell a story. You're not going to impeach those fingerprint experts, even with partials. They either ID'd them or they didn't. That's why there was nothing further done. The deficiency and the criticism is it was a bad strategy. And it puts the outcome in doubt because you weren't going to win the case, but you try to avoid the death penalty.
Well, what is the evidence of another accomplice?
He said in Zaza Marcel...
Other than him saying it. I mean, what have you discovered in post-conviction that indicates that he was not the shooter and that there was somebody else that was involved in this robbery?
Nothing. But if a jury believes it possibly could be somebody else that was the shooter, that's the best you got.
Can you just imagine us writing an opinion that would say that, though?
Well,
I mean, really.
Look,
you might argue that to a jury, but this court could not say something like that.
You don't want to ask me to answer that question because I believe we're all citizens and we're all equally responsible when we impose the death penalty on somebody.
Yeah, but we can't base something to say someone was deficient because there could have been a speculative argument made if the decision was to say it was accomplice rather than that there was an alibi.
It's not speculative. If I'm trying this case, all I got is his words. I can't impeach his words later. He said somebody else was the shooter. I don't put him on the stand. That's an explanation for the fingerprints on the bag. Yeah, he touched the bag. But he wasn't the shooter.
Then the alibi goes out the window.
The alibi should not have been the defense. The defense should have been, I'm not the shooter. Then you don't get the death penalty. Juries don't give the death penalty to non-shooters.
If they believe, they do if they don't believe you.
Well if you put him on the stand.
There's no evidence to demonstrate that there was someone else there, why in the world would a jury believe that he was there and there was someone else who was the shooter, but there's no evidence of anyone else being there?
Well, there's evidence that someone else was there by his own words, made surreptitiously to Zaza Marcel. That's the best you got, Justice Quince. What you don't do is put somebody on the stand and tell this ridiculous story that I found it in the parking lot months before and I mailed it back. That's the end of the case. That's the end of the case. We got a 7-5 vote, death penalty, when just a little bit better strategy might have spared this man his life.
Well, but do you agree that on that, which is that Chipperfield said he was surprised by that, and we have no evidence that they didn't go over the testimony before he testified? How do we deal with that?
There's nothing we can do about it. It's just the way it is. But any experienced criminal defense attorney that's tried murder cases would look at this case, and if we have to go to trial, and we can't plead it out to life, we have to go with the best story we got and tell it through the lawyer. I can sell that to the jury. Maybe he's not the shooter. You only get one chance to do it. Do it right. You don't know for sure he's the shooter. Why? Because there's no one that saw him shoot. There's no evidence. There's no gun. There's no fingerprints on a gun. And what did he say to his girlfriend? Somebody else was the shooter. I was just there. That's the best you got. You go with that. The rest of this trial was just ridiculous. It's the toughest fact situation. And me, as an attorney, knowing that, and it was a 7-5 death vote, it hurts me. Knowing this guy's going to get executed on these facts. And again, all murders are atrocious. But I thought we had equal justice. It just... All right, so procedurally we can't do this, okay? Well, we got all these procedures. He shouldn't have got the death penalty. Thank you.
Thank you for your arguments. The next case is State of Florida versus Johnson. You may proceed.
May it please the Court, Jay Kuba for the State. I'd like to reserve 7 minutes for rebuttal. Blakely is not retroactive. In reaching this conclusion, it's important to recognize that the very right to a jury trial, recognized in Duncan, was not of such fundamental significance that it could be retroactively applied. Blakely and Apprendi are subsets of this holding. Consequently, they cannot rise to a greater level than Duncan. It's also important to recognize that there is no such thing as limited retroactivity. Something is either retroactive to the beginning of the Republic or it's not. Now, I think that what the defense is saying when they argue for limited retroactivity, they're really arguing for the same effect that we would have if Blakely was doing nothing more than clarifying and explaining Apprendi, repeating what Apprendi said in different words. And when we look at Isaac, which is the first district case that started us on this path to conflict, we see that that is exactly what the first district held. They didn't hold that Blakely was retroactive. They held that Blakely did nothing more than explain what Apprendi had already said, so retroactivity wasn't a concern.
Well, if that's the... I agree with you that if Apprendi's not retroactive, Blakely can't be retroactive. I mean, that's how I see it in terms of the analysis. But I was somewhat drawn to this idea that after Apprendi is decided, and the Supreme Court uses the words maximum sentence, everybody, at least everybody in the court, thought that meant statutory maximum. So if 4 years later, I mean, if they had clarified it the month later, we wouldn't have the problem. What is the difference, if any? Is there an analysis if For 4 years, after Apprendi, they're operating under a misconception about the application of Apprendi, and it's clarified in Blakely. Would you say that's still, if you apply it to a period of time before the sentence, it's still retroactive, it's still being applied retroactively? Is that the answer?
I'm not sure.
In other words, is there anything about an evolutionary refinement that allows a defendant, when a court says, well, we didn't mean that, this is what we meant, to get the advantage post-Apprendi, pre-Blakely, of them taking 4 years to explain it?
No, there is not. And the reason why is because when we determine whether something is a new rule, and if something is a new rule, that's the only time we'd be worried about retroactivity, we look to whether or not all the reasonable jurists were clear on that issue. And this court held that Apprendi only applied to statutory maximums or sentence in excess of the statutory maximum. Certainly all the federal circuit courts to consider the issue held that. And courts around the nation reached that conclusion. And it's not a surprise because Apprendi specifically says that a judge cannot impose a sentence beyond the statutory maximum. And it's reasonable that everyone interprets that phrase, statutory maximum, with its common definition, the maximum sentence allowed by the statute. It makes sense that no one realized that the Supreme Court felt it would be a different definition. And that is why they had to come back in Blakely and make that change, because all the other courts in the nation were operating under a different rule. Now, the First District, after Isaac, did come back and say that Blakely is retroactive, and they said that that's what they had actually been saying in Isaac. But that is still incorrect, and that's in conflict with the other district courts in Florida. And what we see when we look at a number of these cases that hold that Blakely is not retroactive, we see that the analysis doesn't usually go much further than if Apprendi is not retroactive, then Blakely can't be retroactive. That may seem at first glance to give the issue short shrift, but it really doesn't, because it's really a matter of simple logic. If Apprendi cannot be retroactive, then Blakely, which adds to and incorporates Apprendi, it cannot also be retroactive because it contains within it all the same concerns that this court had in Hughes regarding Apprendi. And when we apply the Witt retroactivity test, we reach the same result as in Hughes and then some. Those are all those concerns in Hughes as to the purpose of the new rule, the effect on the administration of justice. It's all Apprendi and then some, because Blakely adds to that. One of the effects that a retroactive application of Blakely would have is that it would, in essence, when it goes back through time in its application, because it contains Apprendi within it, it would allow a retroactive application. And that is another reason we cannot allow it, because it would be in conflict with Hughes. Of course, even if Blakely applied retroactively, the defendant did not preserve the issue, cannot be preserved by 3800A. 3800A only applies to sentences that are illegal in the sense that they can't be imposed under any factual circumstances.
You never argued that. You never made that point. District court.
That's correct. In the district court...
The district court invited you to say what you had to say. You had the opportunity to file a brief, unlike, it's not automatic in these.
Correct.
They issued an order, the opportunity to file a brief where you could have raised that.
The district
not
court,
you personally, but the state, I mean.
Right. The district court did issue an invitation of sorts to file a response. However, after issuing that invitation, they did not give the state an actual opportunity to do that response. The state had an opportunity and a responsibility to make sure that the record was clear, and so it moved to supplement 2 times, once because the circuit court clerk didn't get the information correct, and then because the order to show cause had cited to Isaac, and Isaac was still pending in this court. There's a good argument that as a matter of judicial economy, the proceedings in this case should have been stayed. So the state made that request prior to issuing its substantive response, which is the correct procedural way to go about it. But the First District chose to treat that motion to stay as a substantive response, which it was not in any way, and that was a mistake. And it had the effect of preventing the state from making its argument. And
ask you to, as opposed to filing a response. I mean, that happened at least twice in this case, as I recall.
there were 3 motions to file. Yeah. There were 2 motions to supplement the record.
But I guess it bothers me that you would say you didn't have the opportunity when you actually had the opportunity, but you chose, or the state chose, to do something else.
Before any litigant files a responsive pleading, they need to make sure that, first, the record is in a state in which they can make properly their arguments. And second, they need to make sure that the law is in a state that it will best reach the right result. And these are all matters that should be taken care of before a responsive pleading are filed. And I don't think anyone would disagree with that. If the state had filed a responsive pleading and made its argument, allowed the court to rule, and then filed a motion to stay, that would be a bit backwards. So the state did it correctly here, followed proper procedure.
But if the court ended up, majority of the court ended up agreeing with your position on retroactivity, this other stuff beside the point, and you'd probably prefer for us to decide this case on the issue, procedural issue, right?
You are right. Yes. But Blakely, of course, cannot be retroactive, even if it is, wasn't preserved. But as you say, it is much better to decide this issue and finally resolve the conflict and hold very clearly for Florida that Blakely is not retroactive. And I'll reserve the 7 minutes for rebuttal.
May it please the court. My name is Henry Guyton, and I represent the respondent, Saron Johnson. And we are here today to seek to have this court affirm the well-reasoned opinion of the First District in Johnson's versus State. Initially, I want to clarify, as Justice Quince pointed out, the state was given multiple opportunities to file the brief. So the statement that the state did not have an opportunity to file a responsive brief to the First District's request, I think, is just simply incorrect. The state filed a motion. What essentially happened is the First District issued an order to show cause indicating that it was inclined to grant or reverse the summary denial rather than file a responsive pleading or a responsive brief. The state filed a motion to supplement the record and a motion to correct the record. Both of those motions were granted, and the First District gave the state another opportunity to file the brief, saying, send us something within 20 days. The state chose on its own to now file a brief and instead filed a motion to stay, in which the only issue it raised was the retroactive application of Blakely. So we would assert that the only issue properly before this court is whether or not Blakely can be given limited retroactive application. Now, as to that issue, I disagree with counsel as far as this court's power to craft the scope of the retroactive application of Blakely. What the First District determined was that Blakely was a clarification of what the Supreme Court meant in Apprendi. And they recognized that Apprendi granted fairly substantial rights. The Apprendi court determined that a defendant has a right to a jury trial on sentencing enhancement factors, and not only a right to have that determined by a jury, but also that determination be made beyond a reasonable doubt, which was yes, ma'am.
That different from an evolutionary refinement?
Well, I think I think it's a change in the law because this court issued its decision in McGruger versus State in 2001, essentially saying that Apprende would not apply to sentences that did not exceed the statutory maximum. So that became the law in this state. So to the extent Blakely changed that law, it was a change of law. But the purpose of Blakely was to clarify what the Supreme Court of the United States intended when it issued its decision in Apprende.
Well, that's a sort of a nice argument, but where does it fit in with the jurisprudence on retroactivity? Because you're still saying that for the 4 years after Apprende, that judges were, as long as they were sentencing under the statutory maximum, we didn't think Apprende applied. Now, how do you then, if Blakely is then to be applied to this defendant's sentence, you are applying it retroactively. So I don't understand how you get around, because it's a milder situation, it's not a cataclysmic change, it's a evolutionary refinement, you're still applying it or asking that it be applied retroactively. So don't we still have to go through the same analysis that we would go through under Witt? And I think you make that argument. You say, well, we're only asking this for 4 years, so it's not as much of an upheaval as if it went back to the beginning of time. It's only going to be the cases within that 4-year period. But you still have to go through the Witt analysis. Do you agree with that?
I definitely agree with that, Your Honor, and I think that Blakely can be treated differently from Apprende exactly because of the limited scope of the remedy. What the First District determined was that in applying Blakely retroactive for that 4-year period, you are only dealing with a limited class of criminal defendants. One, Apprende was already in application, so therefore you would only be dealing with sentences in which the sentence was enhanced due to judicial findings, but that enhancement did not exceed the statutory maximum. The other issue is just given the time that has occurred here, many of these sentences would have already expired. So it's highly likely that we aren't talking about a large number of cases if Blakely was given this retroactive application.
But the case would still have to be, the state would have to make a decision. Do they go with the sentence that you would have without departing, or they'd have to have another jury trial?
Right. Well, the defendant would have to establish that the error was not harmless. This court established that harmless error analysis.
How about, since we're looking at this case, can you do that to show that it's not harmless?
I think in this particular case, as Mr. Johnson, you would not be able to show that beyond a reasonable doubt. I think at this point we still have a very limited record, but what essentially happened is Mr. Johnson had a recommended guideline score of only 11.8 years, and he ended up getting sentenced to 48 years, over 4 times the recommended guideline sentence, and that was based solely on judicial findings that the Supreme Court of the United States has held should have been determined by a jury and should have been determined beyond a reasonable doubt. And I think
wasn't he resentenced to something a little less?
He was resentenced to 40 years on two of the counts. And there's still one count that has 48 years.
He's still serving a 48 years.
He's still serving.
And what were the departure reasons?
The departure reasons, Your Honor, were unscored juvenile offenses, escalating pattern of criminal activity, and that the crime was premeditated and calculated and premeditated. Those were
the premeditated, calculated would have to. Those are additional. That wasn't encompassed within the crime that he was convicted on. That wasn't an element of the crime?
Yes, Your Honor. That is correct. That was not an element of the crimes that he was convicted on, and we think that those would be factual findings that a jury would have needed to determine.
Because the unscored juvenile offense, it's not quite like the fact of a prior conviction, but it is readily ascertainable. If you only had that, would you agree that might be less problematic?
I think that may be similar to prior convictions, and that may be able to be determined by the judge. Now, in Isaac versus State, the First District determined that the sentence enhancement for escalating pattern of criminal activity was a factual determination for the jury also, so that you would have both of those factors here.
You make or the First District made, and you make an interesting argument. Do we have any cases that take the same principle of law, which here is the jury must find certain facts in order for a sentence to be increased, and apply it differently because the time period is more circumscribed? Do we have any precedent on that?
Well, Your Honor, I think not in the specific way that the First District handled it, but I think in the past when this court has analyzed changes in rules under the Witt analysis, it has noted that because of the limited application, an example I'll give the court is the case of Callahan versus State, and that was at 658 Southern 2nd 983, and that case was dealing with the the consecutive imposement of a habitual offender sentence, which this court in Howell versus State determined was improper, and the court applied its holding in Howell retroactively. And one of the reasons that it did so was it looked and said that the habitual offender statute was amended in 1988. So courts could have only been relying on, and by amended, it was amended to allow for a habitual offender sentence to exceed the statutory maximum. And the court said that the trial courts in the state could have only been relying on that law for 6 years. So therefore, it wasn't a significant reliance on the old law, and they used that as a basis for determining that retroactive application was proper.
Well, you're being I think you're making a credible argument. But isn't there, what's the effect on the administration of justice, which also does mean that sentences end up getting tried by juries when you have a situation, again, where this isn't, I don't know about the premeditated element, but the idea of the escalating pattern is pretty well not subject to a lot of actual dispute. And the jury doesn't know they're going to be deciding between 12-year sentence and a 48-year sentence. So we don't tell, we don't tell them that other than in a death case. So don't we have that concern about the effect on the administration of justice to make this retroactive?
Well, I think anytime you apply any rule change retroactively, there is going to be some effect. But the question is that effect going to be substantial or beyond a level that warrants it? It is essentially a balancing test. And I think what a lot of courts in reading these cases have failed to do is evaluate each factor and come to a conclusion based on all of the factors. And I think in this case...
Now, under what, if it's an evolutionary refinement, do you get into the balancing?
Well, I believe that you do. I mean, I think most of the cases talking about the evolutionary refinement are speaking more under a Teague standard rather than a Witt standard. I think the issue with Witt is whether the case is of fundamental significance. And when evaluating that issue, I think one of the things you should look at is what did Apprendi and Blakely do? And what Apprendi did was apply the beyond a reasonable doubt standard to a sentencing enhancement factor. And that, to me, is a fundamentally significant...
But we've already decided that Apprendi's not retroactive.
Well, this court conducted a Witt analysis, and I think what this court determined, if you read this court's decision, is it was concerned with the fact that if it applied Apprendi retroactive back over the 20-year span that we had the sentencing guidelines, that would essentially be too heavy of a burden on the court system.
Well, what did we say about whether Apprendi was a case of fundamental significance?
This court essentially ruled that Apprendi dealt with a procedural aspect.
Well, isn't that, though, then that really is your bigger problem. If we said that, which we were saying, and I think a lot in part based on the Supreme Court, after they made this whole big deal about Apprendi, said, but it's not retroactive. So it was, if we said that in Hughes, right, Hughes was the case, how can we say something different and say, well, this is a bigger deal than it was when we decided to use?
Well, because the court's analysis, I don't think the court's analysis was limited to a finding that because the case was, well, let me first start by saying, as you stated in your dissent, Justice Parente, there were two issues in Apprendi. One, the issue of the jury trial, and then also the beyond a reasonable doubt standard, which implicated Fifth Amendment due process rights. And as to the beyond a reasonable doubt standard, that isn't procedural. I think that the issue of a burden of proof generally in the court's jurisprudence has been considered a substantive issue, not merely a procedural issue.
Well, however brilliant that dissent might have been, it was a dissent. So wouldn't it require us to recede from Hughes in order to get to your
I don't think so,
point?
because, like I said, in the calculus of the entire Witt analysis, what you considered in Apprendi was what was the purpose of this law, what is the impact that this law is going to, or excuse me, what was the reliance of the law, the old law, the extent of the reliance, and what is the impact on administrative justice. And because Apprendi would have gone back over a span of 20 years and would have invalidated numerous cases that had basically been relying on judicial findings, this court...
But Blakely would have the same purpose.
But it would not have the same impact.
Correct.
Because
Wait a minute.
Oh, I'm sorry.
It would have the same purpose that Apprendi had, to make sure that those factors that would enhance a sentence, that go beyond a prior record, are found by a jury beyond a reasonable doubt. That's the purpose of Apprendi, correct?
That is the purpose of Apprendi. I think Blakely has an additional purpose in that Blakely had the purpose of clarifying what the Supreme Court of the United States intended in Apprendi. And I think that's the purpose that the First District relied upon or latched onto, because they said, well, if Blakely is intended to clarify what Apprendi meant, then it makes sense that Blakely should be applied to cases in which Apprendi would apply. And they said for just this 4-year period, that's a short enough period that to give the full effect of Apprendi, the full penalty. I'm sorry, Your Honor.
Has any other state decided that Blakely is going to be applied retroactively based on those kind of factors?
No, Your Honor, not that I found. I think looking at most of the states have decided the issue. Many of them have followed the Teague analysis, which wouldn't be applicable in Florida. And none of them have addressed whether or not Blakely can be given limited retroactive application. All of them have simply determined, have analyzed it under the thought being that Blakely would go back to beginning of time, which is not what the First District Court did, and which is not what we're asking this court to do.
You certainly couldn't go back to the end of time, because we've already said in Apprendi that we're not going to go back that far.
Correct. And that's why the First District reached the ruling that it did, because it felt that a limited application fell within this court's jurisprudence.
Well, I guess I've looked at this as Blakely being an evolutionary refinement, which I think Witt says basically that it's not applied retroactively if it's simply an evolutionary refinement. You make an interesting argument, but I'm still not convinced that this is not a evolutionary.
I certainly understand the court's point, but I think as far as the case law in Florida, it was a clear change of law. This court issued an opinion that governed Florida saying that Apprendi only applied to, or did not apply to sentences that did not exceed the statutory maximum. So to the extent that that was the law in Florida, Blakely was a clear, definitive change in the law in this state. So I don't think it's necessarily a refinement. I think it is a change of rule of law, just like any other, just like Apprendi itself was. But in sum, Your Honor, essentially what we're asking the court to do is to craft a limited remedy, or essentially affirm the limited remedy that the First District Court of Appeal thought was proper. The basis for that ruling is because this court determined that Apprendi would apply to resentencing in State versus Fleming, that Apprendi would apply to resentences that occurred after Apprendi was decided, even if the conviction occurred prior to Apprendi. The First District determined that to give that ruling its full effect, Blakely should be also given limited retroactive application, so that when those resentences occur, they can be given their full proper effect as the Supreme Court intended under Apprendi.
The problem with that, because I first thought that's what we were dealing with, but we had a whole rationale in Fleming about that resentencing is de novo, so the defendant gets the benefit of the law at that time, so it's not a retroactivity analysis. So then I think that's conflating two really different concepts. But when he was resentenced, Blakely had not been decided, correct?
Correct, Your Honor. When he was resentenced, his resentence became final in 2002, so Blakely had not been decided. So I agree with the court that this would be somewhat different, but I think that it's within this court's discretion to give Blakely a limited retroactive application. I think that would not be inconsistent with Apprendi because you aren't dealing with the same time span, and I think you have to evaluate each case on their own merits under a Witt analysis. And looking at the Supreme Court and its decisions in Duncan and other cases, if you actually read those opinions, all of them are based on the fact that if they applied the decision retroactively, they would be reversing decades of criminal convictions. That was the crux of the holding in those cases, and that's not what is at issue here, and that's why we believe that is distinguishable and would warrant this court affirming the First District's opinion. Thank you.
Blakely cannot be limited because retroactivity, by its nature, is not limited. Retroactivity goes back to the beginning of the Republic.
Well, but that's not. But of all the arguments, it seems to me that's a stronger argument, which is that Apprendi was decided at that time. Everybody assumed statutory maximum meant what it meant and what we thought they were saying, and then 4 years later, the U.S. Supreme Court says no. And as far as whether it's fundamental significance, so this guy might be subject to an 11-year sentence. Instead, he's serving 48 years in the Department of Corrections, and you're only talking about a resentencing, not guilt. The balance may weigh in favor of this. Does the state know how many defendants we're talking about that might have had enhanced sentences, departure sentences in that 4-year period that would have to be resentenced?
We don't have a specific number.
Well, do we have any idea? Is it? I mean, let me ask you this way: what if this was the only case? Would that matter at all? Does it matter whether it's one case or it's 10,000 cases?
For this issue, it would not matter because it is still not an issue of fundamental significance. It is still an evolutionary refinement of the law. It is still procedural as opposed to fundamental.
It may be, but for this defendant, the consequences of it are as significant as it gets. I mean, he'd be out of prison at this point. So I understand we use these words, but let's just be really clear on this, that it's very different when you're overturning a conviction. I think the issues of finality come in. With a sentence that may be unjust because a jury may not have found those aggravators, that's a beyond a reasonable doubt, that's a bigger deal. Now, we may be hamstrung by Hughes, but to say it's just not a really a big deal, I think we sort of throw common sense out the window when we say something like that.
We're not saying that it's not a big deal, but it is a mistake to say that just because something is important to an individual or in general, that it also is of the kind of fundamental significance that we consider under the Witt analysis.
So in Hughes, we didn't have to get any farther than saying it's not of fundamental significance. The issue of, because you keep on talking about it, this goes back to the beginning of time, and I was just responding to that. So let's just, assuming it doesn't go back to the beginning of time, it goes back 4 years, and assuming there's only a couple of cases, would you say that under the court's Hughes opinion, this defendant is still out of court because Hughes treats it as a procedural issue?
Yes.
Okay, so that's really the better way than to go rather than argue about the length of time, because there is something appealing. I know in Callahan that you do look at how many sentences, and sentences are not as big a disruption on the court system as retrying a defendant's guilt. Right.
That would be true. However, if we were impaneling a jury for a resentencing, the ultimate effect would be the same for logistics, for the time period. We would have to get a jury. We would have to find all these witnesses that now, from the original sentencing in 1996.
What kind of witnesses were there?
I'm not aware. But any witnesses...
because I thought it was, there's an unscored juvenile proceeding. Is there, and again, maybe because we don't know this record, is it clear it was premeditated? I mean, what was the crime here?
Because we don't have the full trial transcript, we don't know exactly what happened originally. However, even if there were no specific witnesses called first, in order to prove this to a jury, the state might need to do that now. So what happened before wouldn't necessarily determine what happens now. I'd like to touch on something you mentioned, that the defendant is really at a disadvantage here. This court recognized in Hughes that that is not the case, that there really is nothing to say that the procedure we used before of a judge finding the facts has any less validity than a jury finding the facts, even under slightly different standards of proof.
But then the issue of it being found beyond a reasonable doubt is, I obviously didn't convince other people of this, seems like it's not procedural. I mean, beyond a reasonable doubt is a significant standard, but I didn't prevail.
Yes, Your Honor. This court in Hughes recognized that that was not a factor which swayed the analysis, and ultimately there was still no reason to question the validity of the procedure. And ultimately, under Witt, that's what we're looking for. That's what all these factors help us determine, whether the validity of the procedure is really in question. This court reached the conclusion that it did not call that into question. It's a matter of logic that because Duncan, the right to a jury trial, is not retroactive, and because this court has held that Apprendi is not retroactive, Blakely, which contains within it and adds to both of those prior holdings, Blakely itself cannot rise to the level of fundamental significance to be retroactive. The state asks that this court quash the opinion of the First District, reaffirm the trial court's holding that the defendant's motion was properly denied, and hold that Blakely is not retroactively applied. Thank you.
Thank you for your arguments. The court will be in recess for 10 minutes.
All rise. All rise. Supreme Court of Florida is now in session.
Our last case for the day is Nunez versus Geico. You may proceed.
May it please the Court, Juan Montes on behalf of the appellant Merly Nunez. This Court has before it a question certified by the 11th Circuit Court of Appeals, the question being whether under Florida Statute 627736, an insurer can require an insured to attend an EUO as a condition precedent to recovery of PIP benefits.
Off the get-go, I can understand correctly what goes on. How does this happen? I mean, let's assume for a second that I'm involved in a car accident. I want to go see a doctor. Required to go give one of these testimony. How does that work? Do I get a letter? Who takes my statement?
Well, that's an interesting question because it all depends on the insurance company and what they do. In some cases, you may get a letter from the insurance company asking you to come in for a statement at their offices. In other cases, you may get something that looks like a subpoena sent by an attorney hired by the insurance company or sometimes even by the insurance company telling you to go to a particular place and bring a series of documents and leases and phone records. And
who takes the statement? Is it a lawyer that represents the insurance? Or is it an adjuster or maybe even a secretary?
Sometimes it's a lawyer. Sometimes it's an adjuster. There's usually a court reporter present for most of these statements. It really depends on the insurance company.
Have the right to bring.
Well, I don't know of many circumstances where the insurance company will tell you you cannot bring your lawyer, except that I know that it has happened.
Well, but if a lot of these cases at PIP time, they may not even have a lawyer.
No, in most of the cases, at this point in time, they don't have a lawyer. And these notices go out, like to answer Your Honor's question, it could be a letter, it could be something that looks like a subpoena. Sometimes they have ducis tecum. There's no particular format that is followed. Every insurance company does things a little bit differently.
But the legislature has now authorized this.
The legislature, based upon the last legislative session, has authorized.
Have they put parameters on the EUOs?
They actually have, because the statute itself says that the insurance company is limited to obtaining information that's relevant information, or something that might be relevant. It's not an open-ended examination the way insurance companies usually use it prior to the amendment. Furthermore, in the amendment to the statute, there's a provision that says that an insurance company uses an EUO as a business practice and requests it when there's no reason to, that's a violation of Florida Statute 6269541. So there are certain restrictions that are placed by the legislature to prevent the type of abuses that bring us here today.
I read this policy. Many of these statements are reasonable. So is there any limitation in the statute about the taking of these kind of statements?
In the new statute, no. There's no limitation as to how, what is reasonable or how many you can take. It's silent as to that. However, there was no provision in the statute before the amendment, which makes it even more of a reason why.
Let me ask you about another statutory provision, and I don't think this is a statute that you actually talk about in your briefs. It is a statute that's mentioned in the 11th Circuit's opinion certifying the question, and that is Section 627.414, which has to do with additional policy content. And that statute says that a policy may contain additional provisions not inconsistent with this code, which are, and then it gives three different options, but one category there is desired by the insurer and neither prohibited by law nor in conflict with any provisions required to be included therein. Now, why doesn't this provision have some application here? Would you contend that this provision doesn't apply to PIP policies?
For the most part, I do contend that it doesn't apply to PIP policy. That provision is put in there when the insurance contract is a contract between the insured and the insurance company, and it's not something that's mandated by law. PIP.
But that's not what the statute. This is in the general provision of the statute, Chapter 627, and we look at the scope of this part in which this occurs. It's very broad. The scope doesn't exclude PIP policies. And furthermore, there's a definition of policy in this subpart, which is very, very broad, and I can see no reason that it would not cover PIP policies.
Well, The reason it doesn't cover PIP policy is because the statute itself also says unless there's a conflict with the policy. And in this particular case, there is a conflict.
So you're saying this would apply, but they don't get but it simply is not a permitted additional provision because there's a conflict.
Right. There are various conflicts, actually, between the PIP statute.
Now, I've read your briefs, and I'm having trouble understanding the conflict. Because this is a provision that requires showing up for an examination under oath. It's not a limitation on coverage. It doesn't seem to me, because it doesn't affect whether somebody has coverage. Now, it may affect whether, if they don't comply with it, it might affect whether they get paid, because if they fail to comply with that requirement of the policy. But it's not in the nature of something that would actually restrict coverage. It's just so why isn't this something that would fall directly within the scope of this provision that allows additional policy provisions that are not prohibited by or in conflict with the code?
Because, in fact, they are in conflict with the code, particularly the PIP statute. PIP is a statutory creation. The legislature within the PIP statute placed in there what the different conditions are that the insured must meet in order to recover PIP benefits. An EUO is not one of those conditions, and that's pre the 2012
but this
amendment.
whole thing is obviously talking about, it says a policy may contain additional provisions that must be additional to those that are specifically provided for in the code. Otherwise, this would be meaningless, wouldn't it?
Correct, but there's a now you have to deal with the issue of the conflict. There is a conflict because the PIP statute was placed in there in return for the taking away of the tort rights of accident victims in order to get them what's called swift and virtually automatic payment. And these are terms
how does this affect the swift payment? Because the swift payment is not instantaneous. Now, I understand you make an argument about, well, there's due and payable when submitted or when the loss occurs. And the statute says that. But they've got 30 days after the claim is submitted to pay, right?
Correct.
Well, how is this inconsistent with an insurer requesting the submission to an examination under oath within that 30-day period before they have to pay out, before they're required to make the payment?
Because the insurance company is now saying that if you don't show up to the examination under oath, as we direct you to, because they're picking the location, the time, the date, everything about it, and sometimes telling you what other documents you need to bring in order to the EUO. If you don't go, they don't pay, okay. And that's not one of the
the questions about whether a particular insurer uses such a provision in a way that is unreasonable, or they try to impose additional requirements that go beyond what the policy actually requires. Those are separate issues, it seems to me, from the basic issue about whether they've got the basic right when somebody's making a claim to require that they come in and answer questions under oath. And there's a lot of talk here, it's in the case law, about all the fraud connected with PIP claims, and I think you'd have to be, you'd have to be from another planet not to be aware of that. And it just seems to me to be would be a very strange thing for us to say that an insurer cannot take a step such as this to help prevent the kind of fraud that is rife in this system.
Well, the issue here is not whether or not they can request an EUO, it's whether it can be a condition precedent. And that's really the issue the question that's been certified, and that's the issue here. Can you make it a condition that if you don't go, you just flat out, you lose right to get PIP benefits? And that's what happened here, and that's the actual question certified. The PIP statute in Section 5B also...
But does the record here show why they didn't go for the examination under oath?
It is in the briefs. The GEICO in this case requested and said unilateral examinations under oath, where they chose the time, location, and date. They were asked in writing by Ms. Nunez's attorney, to please reschedule for mutually convenient date and time. They ignored the letter, sent another request for a different date where they chose the date, time, and everything. They were sent another letter by the attorney saying, again, we're requesting that you reset it for another date, time that's mutually convenient. They said, we're not paying PIP benefits. That's factually what happened in this case, and that's the reason that the
What was
EUOs...
the claim here? What was the amount of the PIP claim here?
I'm not sure if it's in the record. It might be. I think it was like $1,200. It had to do with some diagnostic bills, if I remember correctly.
Had they paid anything?
No.
So she's in an accident. She notifies the insurer of the accident and goes to see doctors and then submits the claim. And then the next thing is the GEICO says we want to have an examination under oath.
Correct.
Was how quickly after she submitted the claim was the first request for one of these examinations?
I would have to look at the record. From memory, I can't be sure, but I don't. I can try to look, but it might take a little time.
So the issue though is, if it's not a condition precedent, and we have this issue pending in Custer, correct?
Correct.
Then it would be a question of whether the insured acted unreasonably.
Correct.
And that would have to be litigated.
Correct.
Okay, so this is just preliminary to whether, but you would agree that if they acted reasonably, couldn't get information, and they didn't, it might be a basis to at least deny that particular claim.
Well, it could be or may not be. The problem is when you make it a condition precedent, and in the statute didn't make it a condition at all, the insurance company could simply say we're not going to pay.
Now, is it now a condition precedent? Is it now under the statute?
It is now condition precedent, but what this court needs to look at is the
it is now. It is.
According to the legislature, the way they wrote the statute, I think that there's issues with the language of the statute that might be before this court at some point in time. But the way they wrote the statute, it does say it's a condition precedent.
But your position is that this is an invalid provision of the policy. Am I correct? The provision that allows the insurer to require the insured to submit to an examination under oath.
An insurance company could call the insured and ask them
Well,
questions.
I understand.
They can request the examination under oath. But the problem is
But you're saying it's inconsistent. I thought you were saying that policy provision is inconsistent with the PIP statute.
It is.
That would mean it's invalid.
Well, it's invalid as a condition precedent. As a condition subsequent, it might be a different story, or as part of a cooperation.
Explain to me the difference between the condition precedent and the condition subsequent.
Well, for example, if the insured doesn't show up and it's a condition subsequent, the insurance company has to show that they were prejudiced somehow by the non-attendance by the insured. If you make it a condition precedent, if someone doesn't show up, they just allow them to unilaterally cut off PIP benefits. And in cases like in Ms. Nunez, it's not that Ms. Nunez refused to show up. She requested that it be set for a mutually picked time, date, and location. If you allow the insurance company to pick all of the above, and then in some cases send you a notice saying, bring with you a copy of your lease, a copy of your auto payments, and some of these insurance companies have very long lists of things that they put in, things that look like subpoenas, to dissuade insurers from showing up to EUOs, so that they can say, you didn't show up, we're not paying.
It seems like to me, however you characterize it, if the insurer places conditions on the compliance with this provision or tries to enforce it in a way that's unreasonable, that the insurer's going to lose if they don't conduct themselves in a way that is reasonable under the circumstance.
That should be the case, but unfortunately, Your Honor, that's not.
But that wouldn't depend on whether it's condition precedent or a condition subsequent.
No, it is, because if it's a condition precedent, simply not attending, you're out. And in this case,
you mean to tell me if they say, you're set at 5 o'clock on Saturday morning at 100 miles from where you live, be there or you lose, that you're saying that if it's a condition precedent, then that's the end of it. They can do anything they want to, and that would, just because it's characterized as a condition precedent, the insurer wins.
Correct. And that's how this case actually got up to the 11th Circuit Court of Appeal, despite the fact that there was never a refusal by Marlene Nunez to give a sworn statement. She just wanted it to be reset at a mutually convenient time, place, and location and a date.
Is there a separate claim at the 11th Circuit other than the precedent argument on the interpretation of the policy that the actions by the insurer was not reasonable, so that even if it is a condition precedent, the actions by GEICO were unreasonable, therefore your client's entitled to recovery? Is that a separate claim apart from the certified question here?
I'll answer a question in the way it came up in the 11th Circuit. In the initial motion to dismiss, simply the argument was you can't make an EUO as a condition precedent because the statute does not provide for it, and it's contrary to statutory interpretation to add something in the PIP statute that's not in there. When the court issued a motion to dismiss, because this went up on a motion to dismiss, we did a motion for reconsideration with an amended complaint saying, well, at the very least, need to then consider whether or not there was an unreasonable refusal, and there was some case law from lower courts that said the insurance company must show that it was an unreasonable refusal to attend and that they're prejudiced. The court denied the motion for reconsideration or the right to file an amended complaint, and then we went up to the 11th Circuit.
In this case, did the insured submit the standard proof of loss, which is a sworn statement under oath of the loss?
My understanding is that the only thing that at this point that GEICO said that they needed or wanted was just the examination under oath.
That's not what I asked.
I believe so, but I can't, with all honesty, tell Your Honor
well,
that.
How did the claim become generated? I mean, it's my understanding from doing this for 40 years is that the Department of Insurance and the regulations have certain forms, and the forms are under oath that you have to give to an insurance company to notify them of the loss and the amount of the loss, because it says so in the statute, doesn't it?
Correct.
Was that done in this case?
I believe it was, Your Honor. My understanding is that there was nothing other than the EUO that was holding this case up.
Right, so there was a statement under oath as to the loss sustained and the amount.
And the information was provided, yes. And it was provided. Notice of covered loss and amount thereof was provided to the GEICO. The issue is they wanted an EUO. Ms. Nunez never refused to attend the EUO, but the insurance company refused to.
So those provisions for some other statement under oath are in conflict with the actual statute itself that requires under oath the submission of the bills. I think it's called statement of amount and or the statement of the loss and the amount thereof.
Yeah, notice of covered
and
loss
those are the
and amount
words in the statute?
Correct. And in fact, the statute in Section 5B actually provides specifically the circumstances in which an insurance company can deny payment of a PIP claim, and non-attendance at an EUO is not one of those circumstances, which is one of the conflicts, Your Honor, that I was mentioning earlier. One of the several conflicts that we have here is because that failure to attend an EUO was not one of those circumstances. Insurance companies have other ways that they can discover information. In addition to an EUO, under 6B, they can get an order permitting a right to discovery from the court. They just have to show good cause, but insurance companies don't want to do that. And again, the issue
is it appropriate to require the claim under oath that Justice Lewis described as a condition precedent?
Not as a condition precedent. In fact, if you look at what the Michigan Supreme Court did,
so there should be no requirement of a claim under oath as a condition precedent.
That's the condition precedent to benefits. Is the form that the insurance commissioner provides.
Correct.
Well, that's what he just asked. Is that the form, the statement under oath of the claim and the amount thereof, that's required under oath as a condition precedent to payment?
Those are what's actually required under oath. The EUO itself, however, is...
No, I'm not talking about EU. I'm talking about the form.
Yes, the forms. That's required.
Well, that's what he just asked.
Oh,
if you don't submit the form, you don't get paid.
Oh, that's correct.
So that's a condition precedent?
Yes.
Okay.
Yes. And we're simply saying that an EUO is not. Now, if the insurance company needs information in order to have to pay the claim, and they want to call the insured, request an EUO of the insured, we're not saying you can't do that. But if they already have notice of a covered loss and the amount thereof, and they have all the information, they can't simply request an EUO just to create a condition for not paying a claim.
But I thought you said they could request it. It's just that the consequences of not attending is not automatic forfeiture of benefits.
That's correct.
The insurance company would have to show prejudice.
Correct, which would be a condition subsequent. And here it's being used as a condition precedent, and that's the problem here. Because then you just don't go, you can't even raise it. And in this case, that's exactly what happened. You forfeit your benefits.
That's why the complaint was dismissed?
Correct.
And as a matter of law, they said you forfeited by not going at the time that Geico wanted your client or the client to go.
Correct. And this court actually did the analysis in the 2010 case of Custer versus United Auto. When that issue came up, there was in part of a footnote, but that was about a page long, and there was also another section that dealt with the Goldman decision, talking about the fact that Goldman is not a statutory type case, where this court actually went into the correct analysis that you cannot place conditions on a statutory coverage that are not provided by the statute.
You've expired your time. I'll give you another minute for rebuttal.
Yes.
May it please the court. I'm in counsel. I'm Suzanne LeBritt. It's my pleasure and privilege to represent Geico in this appeal. We submit that the certified question should be answered in the affirmative. The question is whether a policy provision requiring an EUO is a permissible condition precedent to PIP benefits under the statute, and we've argued and will argue today that it is. I want to address the procedural context of the case because there were some questions about that. The pleadings in the district court were 4 counts: a claim for benefits, a couple of debt relief claims, and a breach of contract claim. And what is on appeal is only the dismissal of the debt relief claim, which is the question, is an EUO policy condition permissible within the PIP statutory framework? So that
as a condition precedent.
As a condition precedent to benefits.
And you would agree that if it's a valid condition precedent, then the insurer does not have to show prejudice.
Yes, I think that may be a precipitous question here because all we're talking about is a condition precedent to benefits as opposed to a condition precedent to suit.
Well, we have. I had said it was Custer, but it's actually State Farm versus Curran, and involves uninsured motorists, but involves the same issue about whether there can be a forfeiture of benefits if the insured doesn't appear at a medical examination. And so that concept of who has to show either prejudice or lack of prejudice is an issue that might directly impact this case.
I don't
agree with that?
I don't disagree, Your Honor, and I'm familiar with
agree?
the Curran case and the facts of that case as well as the legal arguments. I watched the arguments in the case. But I think that the distinction for Curran that is probably relevant today is, for purposes of the question that's certified here as compared to the issue that's presented in Curran, is that in Curran we're dealing with the remedy for the issue of whether the IME provision there was a legitimate condition precedent in the UM framework, I think is out there, but it wasn't the primary issue. The primary issue was the legitimacy of the forfeiture of the insured's benefits at the conclusion of the litigation.
But I guess I thought the two are intertwined because if it's, at least is the way it's being argued here, and I recall it being similar in Curran, if it's a condition subsequent, then the reasonableness of what the insurer is asking or what the insured is doing and whether there's any prejudice become relevant. Whereas if it's a condition precedent, you don't do it and you lose all. I mean, what Geico's seeking is, because she didn't go to this examination under oath, is she doesn't get any PIP benefits. Is that correct?
That is the outcome here, and
none. Not only just for this $1,200, but for any amount up to the $10,000.
Well, Your Honor, I think that in practice, in a general context, it's important to remember that this case comes up as a class action. So the issue of reasonable, unreasonable, and so forth is something that would be suitable in the 11th Circuit. But at least to answer your question directly, and I do want to try to do that, the condition precedent to benefits is a defense that Geico would plead.
I just want to understand, to the whole 10,000, even to anything, like it's nothing she could remedy if she loses that $1,200 bill and now she submits, say she's got a herniated disc and now she goes to surgery because she didn't do the EUO for the first diagnostic test, she gets no benefits?
Your Honor, I don't know the answer to that question,
but
I suggest
Geico must have written a letter, and I have seen there's nodding going on. They go, you have forfeited your benefits. We're not paying the $1,200.
I believe that Geico's position here was that benefits on this claim were denied for failure.
But this is a big deal. I mean, it's a big deal because if it's a $100 bill. And you make a decision. Listen, I'm sick. I'm still aching from this accident. I'm not going to this office, but all I'll lose is the $50. I need to go when I'm a little stronger. But if you say you don't go, if you don't get out of bed and go, you lose all $10,000. That's a pretty significant forfeiture.
Well, I think that I think it's a question that's beyond the scope of the question that's certified here today.
But that's the result. I mean, you can't ignore. We'll decide this one today that's a cup. Well, that cup holds water. I mean, you got problems with it.
And I think the court may get the opportunity to adjudicate the question independent of this case, given the way the legislature wrote the 2012 amendment.
We can't start guessing on what may be coming in the pipeline.
But what I wanted to suggest is that what was done here is benefits on the claim that was submitted were denied. The court has, in the Flores case, which is also relevant to the analysis here, particularly to what Justice Kennedy asked about, confronted an issue that's not dissimilar to what Justice Parenti just described, which is if, in that case, I believe that the claimant was claiming PIP and UN benefits. The claim was fraudulent as to the PIP benefits, and the case proceeded, which had been exhausted by the time.
Was there a written claim under oath?
There is no record of a written claim under oath. I don't know the answer to that question.
Okay,
I do know that the record.
What about the distinction? He says, your opposing counsel admits that if there were a written claim of oath, or that there should be a condition precedent for a written claim of oath. If there's not one, then no benefits to be paid under the policy, as I understand his argument. But he distinguishes that then from an examination under oath, where he disagrees that there should be a condition precedent. Could you address the distinction of those two things?
Well, I think I can. First of all, I want to say that the record that we have is limited because of the proceedings in the 11th Circuit, but to my knowledge, that record does not have a statement under oath.
Well, how is a claim generated? How is a claim generated? I mean, that's disingenuous to come and argue to this court. This is a very practical application of a PIP statute. A claim is generated in some fashion, and insurance companies, do they not still have the form that's printed and that's approved by the insurance commissioner's office on setting out what the claim is, the bills that you have, the time that you've lost, under oath?
Your Honor,
and doesn't the statute require
it? I believe that the statute does require the submission of a HCFA claim form by every provider who wants to be paid. And I also believe that, and I wasn't sure when you were questioning earlier if you were talking about the provisions of 6B that require providers to give a sworn statement with regard to the condition.
And the insured. The insured has to submit bills under oath.
And I wasn't sure which part of the statute.
Well, is that correct?
Well, the way I read 6B is every physician, every provider.
Could you just answer the question? Is there something in the no-fault statute that requires insureds, when they submit a claim, that the bill or the amount they claim has to be set forth, and the amount, and it has to be under oath?
I don't know the answer to that question.
You don't know the answer to the PIP statute?
As to whether insureds have to submit bills under oath, I don't know the answer to that question. I do believe that the statute has a specific framework for provider submission of bills, because that's generally how we see it. And I don't know, I assume, but don't know, that a provider bill was submitted here. We don't have the benefit of it in the record or any information about how the claim came to be the first.
But there's no defense in this case that they did not submit a proper claim?
No, Your Honor, there is no defense to that effect. But just to be clear as to what is in the record. And So I think that the issue of what would happen in terms of condition precedent to benefits, condition precedent to suit, is important, and it's important to answer the question with regard to the current case. The EUO condition is a condition that it's a condition that the legislature has now pronounced should be followed, and the purpose of it is to enable the insurer to verify the basic predicates of the claim. And compared to an IME, which assumes that the claim is covered and goes to the propriety of continuing treatment, if the insured refuses the EUO, the insurer can deny that claim, and the insured is free to bring suit. And one of the defenses can be that the insured...
I'm sorry, you said the insured can deny the claim. The insurer can deny the claim, and then the insured can file suit.
That's correct.
And so how did this one develop? I thought there was a suit that had been filed.
The suit was filed, and the issue that became the issue on appeal is simply and limited to whether EUOs are a permissible condition precedent under the pre-amendment statute.
At the trial court, when the complaint was filed, it was dismissed?
That is correct. Because
of failure to attend the EU.
That's correct. And the trial court also found, for purposes of this appeal, that EUOs are a legitimate condition precedent. And by
dismissing that complaint, the insured now has no remedy at all. I mean, it's not like they can file another complaint, is there?
No, Your Honor. So going back to the original question, the thing is an EUO a permissible condition precedent under the pre-2012 PIP statute? Because we know now, going forward, that it is a permissible condition precedent.
Which brings me to the other question I wanted to ask is, at the trial court level, there was never any discussion of whether or not the insured's failure to appear was reasonable or not?
I believe that it was pled generally, and I would cite the court to the district court's opinion as well as the briefing in the district court, where it is acknowledged that the only issue on appeal was the propriety of the declaratory statement that EUOs are a permissible condition precedent.
With that going with it, just so we're clear, because it otherwise sounds like it's up in the air. If it's a valid condition precedent, then the insurer does not have to show prejudice, and the insured forfeits the entire amount of the PIP benefits. I mean, it's got to be either it is or isn't.
Right. I'm not sure that does the insured have to show that the insurer was prejudiced by the failure of the EUO, or does the insurer have to show that it was prejudiced? I'm not sure whose burden that would be on the failure of the condition precedent, but it would certainly be a material component of the litigation that presumably would result.
In your point, or maybe I'm misunderstanding here, but you're saying that a lawsuit could be brought, and in that lawsuit, be litigated whether the insurer sought to enforce compliance with this condition precedent in a way that was unreasonable.
That's correct, Your Honor.
Okay. And so the argument here that the insurer can just jerk people around and then deny them benefits, and that's the end of the story because it's a condition precedent, that's not really correct, because there can, if I understand what you're saying, that the issue of whether the insurer acted in a way that's consistent with the contractual requirements and the whole scheme, including that provision of the policy, would be something that would be subject to litigation. And if somebody's saying, I want to show up, but you won't set a time when I can be there, then that's a whole different story that could be litigated.
That's correct, Your Honor. It's not a condition precedent to suit such that failure to follow it extinguishes the lawsuit upon the raising of that defense. And in candor, and on this record, that was part of what was argued in the district court. Now, with the development of time in the record in this case, the position is not that it's a condition precedent to suit, it's a condition precedent to benefits. And to the extent, if the insurer asks for the EUO after the 30-day investigative period or on the 29th day and wants the insured to do it at 3 o'clock in the morning in some ridiculous place, yes, that is an issue that would be litigated. The assumption, presumably, that the legislature made when it amended the 2012 statute is that insurers would be reasonable, and if they're not, they're going to suffer the penalty associated with.
So was that a part of the complaint that was filed in this case, or was the complaint simply that an EUO is an unlawful condition precedent? Was there any allegations that steward trying to cooperate, but you just cut them off?
The allegation was directed to whether GEICO could unilaterally set the time and place, and the record suggests that the main beef was the place, in whose office, which lawyer's office.
So there was some discussion or allegations concerning wanting to set it at a different time.
Yes, on behalf of the class, the plaintiff pled that GEICO should be precluded from and enjoined, and otherwise class relief should be awarded to keep GEICO from engaging in unreasonable use of the EUO procedure. And the plaintiff's claim was predicated on the notices in this case, which weren't to her liking in terms of the location. But
that's not, all of that's kind of interesting background, but it really it's not what the 11th Circuit has asked us to address.
Agreed, Your Honor. And the question really is, EUOs or insurance are nothing new. Now, there's a wealth of law in areas outside this framework, fire, life, et cetera, that is generally recognizes that we've had EUOs since the 19th century, and I realize that law is general, not specific to this framework. But when the legislature enacted PIP in 1971, it presumably was aware of EUOs generally, and it didn't prohibit them. So we look at now what you suggested, Justice Kennedy, 414, in the PIP statute, and we also have the benefit of this Court's guidance in Flores. And the question is, there is, and this, I believe Justice Perriente wrote this, that EUOs, that there's no blanket prohibition of conditions to coverage in PIP or or other mandated and regulated forms of auto insurance. And so the analysis that Flores requires is, does the condition exclude coverage, and would enforcement of it contradict the purpose of the PIP statute?
I understand that if your position that this is a condition precedent, but it seems like to me it's a condition payment not to coverage but to the payment of the benefits. Is that a fallacious distinction?
No, and I don't think it's necessarily fallacious, and I think it may address Justice Perriente's question about multiple claims to the 10. The legislature wrote, and GEICO is going to follow the statute as the legislature wrote it, it's a condition precedent to the payment of benefits. Compliance with this paragraph is a condition precedent to receiving benefits.
Well, the terms of the policy is that it's a condition precedent to any action being brought against the insurance company, right?
Oh, I don't believe that this policy says that, Your Honor. I think that this policy says that it's a condition, it's in the general conditions of coverage. It doesn't have the language that the current policy had until an action is brought.
I guess I'm still, I just want to understand this. Since the coverage in this case is the PIP benefits, if they denied the benefits, not just for this claim, but generally, then that's, I don't know, I'm not sure I understand the distinction you're making for
I don't know, but the benefits that were denied in this case were denied on this claim. Now, if it was $1,200 worth of benefits, I think that was the number that was thrown out. Could Ms. Nunez bring a second, could she submit a second claim for the next round of treatment or an unrelated condition that arose from this or another accident and have that processed and sit for an EUO and receive her benefits? I think the answer to that is logically yes, it's another claim. And given the wording that we now have that helps from the legislature that says benefits, it doesn't say a complete defense to coverage, which I think is more in the nature of a condition precedent to suit.
I guess we haven't looked at this, but it sure seems that if every time a bill is submitted, the insurance company says, now you got to appear for another examination, we really have taken this PIP statute, which is supposed to be an acceptable alternative to being able to file suit, and we have gutted it. I mean, it can be really, I don't know what's happening, we haven't seen it, but it just seems that that would take somebody who's been injured and take everything and say, well, I might as well see if I can file suit because I'm getting jerked around by this insurance company.
Well, the provision for the EUO is not a mandatory provision in the sense that insurers are not being mandated to use it every time. It's a condition that's available for the insured to investigate, you know, was this car in this, was the car that, is the policy that we wrote, is it a covered loss within the meaning of the policy that we wrote? And that, Your Honor wrote an opinion on this, I think it was Rodriguez, speaking to the 30-day time period that insurers have to authenticate claims. The Florida courts have recognized that EUOs are a valid method to authenticate the claims. They're relatively expedient. It's non-intrusive. Come and give us a sworn statement that tells us when, where, what, who, so that we can verify the coverage. And I don't know what the claims practice is, but I don't think they happen in every single case. The idea is that if there's a question based on the claim paperwork that's submitted that raises a question as to whether this loss is covered, it gives the insurer an expedient way. And if the insurer doesn't do it right, if the insurer is unreasonable or if the insurer waits beyond the 30 days, the insurer is at its own peril for penalties, for interest, for attorney's fees. And it's much less intrusive than the bill of discovery or other means that happen once litigation is underway. So it works both ways for insurers.
Now, since the outset of no-fault insurance in the 1970s, the statute has always contained a section that deals with discovery of facts about an injured person in dispute, correct?
Yes, Your Honor.
And never until 2012 has there ever been a provision for examinations under oath.
I agree, Your Honor. And would submit that this provision, that the EUO provision, is one that falls within the 414 and the Flores analysis, which is it's not contradictory to the purpose of the statute. We've briefed that. And to answer this question in the negative would effectively have this court both knowing prospectively what the legislature has directed, but also would require the court to overturn 40 years of PIP precedent where EUOs have been used. And starting with the Amador case, we have cases that acknowledge the use of EUOs as a means of verifying these claims.
But those cases are all based on non-statutory coverage cases.
Oh, Your Honor, the Amador case, which was decided in 2000, acknowledges specifically the propriety of an EUO to
based on what authority?
Amador, I believe, relies on the Willis versus Huff case.
They rely on all of the property damage losses, life losses. None of them rely on statutory mandated coverages.
I don't think the issue was ever decided directly,
well,
and if it
that's
was,
because they didn't cite those cases.
No,
and isn't it true that at least for the last 40 years that financial responsibility, mandatory coverages, and policies that comply, no-fault insurance policies that comply with the statute, uninsured motorist policies, coverages that comply, have consistently held for 40 years until the Amador case that you could not have exclusions, conditions, and limitations that restrict coverage that are not provided in the statutory provision.
I agree that that's a general principle, but further that those provisions are permissible under 414 and the Flores analysis if they are consistent with the purpose of the PIP statute.
But there's no case that holds that. I mean, for example, under financial responsibility, A1 Fargo out of the 3rd District in the 1970s said that you can't even have a geographic limitation, even though that's all you paid for. In the uninsured motorist context, under Salas, under every case, they say you cannot do that, and they don't use the 414 to change that, do they?
No, Your Honor, they don't. And I would just cite the court to the cases over the last decade that indirectly do acknowledge the use of EUOs and the propriety of EUOs in this setting, and the fact that the legislature did nothing about it for all the times it's amended the statute in the last 10 years. And when the legislature finally did do something, it was after the Custer with the footnote and the question that we had, and what the legislature's inaction for all those years is properly construed as a ratification. The legislature's action with regard to enacting the amendment is construed as a clarification. We'd ask that the court answer the question in the affirmative. Thank you very much for your time.
The problem with judicially writing in a provision in a statute that doesn't belong there is that there are no conditions or limitations, which is what happens here. To answer Your Honor's question, if the insured doesn't show up for an EUO, they waive all their benefits, not just any particular benefit that's due at the end. It's gone. If they show up and then they go to further treatment and then they request another EUO, the same thing. So at the end of the day, there are no restrictions. This is not a provision that's placed in the statute for a reason, and it's not something that you can allow an insurance company just to create in an ununiform manner the conditions upon which insureds in the state of Florida could recover PIP benefits, because otherwise then you don't have a unified PIP statute. You have a PIP statute with every different insurance company that could place conditions on it. So one Floridian may not have the same PIP coverage that another Floridian would have. And I respectfully submit that even in the Quran case, this court had one of the issues was that the policy did not define the circumstances under where you forfeit your right to coverage. And we have the same situation here, because the PIP statute actually says these are the conditions upon which you lose coverage, and this is not one of them. And there's nothing in the policy that says if you don't show up to an EUO, you lose PIP coverage, but that's certainly the way insurance companies interpret it. Thank you.
Thank you for your arguments. Court is adjourned.
All rise.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
Thanks, Cole and Annalise. Florida State has put in place a new system that will change the way students get their ticket to the big game. 4FSU reporter Taylor Trujillo has the details. Students can check out how many loyalty points they have by visiting Seminoles.com. That's where you can also find out more information on this new program. During the opening game against Oklahoma State in 1978, the legend of Chief Osceola and Renegade began. One of the best traditions in all of college football happens in Doak Campbell Stadium. Before the opening of each home game, a student dressed as Osceola, a Seminole Indian leader, charges down the field on Renegade, the horse. Chief Osceola then sticks a flaming spear in the middle of the field. Drake Anderson is the student chosen to be Osceola. He says being Osceola is a big commitment and a lot of hard work. Yeah, I slurred it a bit. Okay. One of the best traditions in all of college football happens in Doak Campbell Stadium. Before the opening of each home game, a student dressed as Osceola, a Seminole Indian leader, charges down the field on Renegade, the horse. Chief Osceola then sticks a flaming spear in the middle of the field. Drake Anderson is the student chosen to be Osceola. He says being Osceola is a big commitment and a lot of hard work. This is Drake's last year at Osceola. This is Drake's last year as Osceola. A new writer has been recruited and will be taking the position of Osceola when Drake graduates. Philanthropy, the Greek student body, cheerleading, and a cause. What does that spell? Cheers for children. 4FSU's Andrea Vijaba tells us about the event. Did I get that right, or Villalba? Viaba, okay. 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 This is Drake's last year as Osceola. A new writer has been recruited and will be taking the position of Osceola when Drake graduates. Philanthropy, the Greek student body, cheerleading, and a cause. What does that spell? Cheers for children. 4FSU's Andrea Villalba tells us about the event. Catch next year's Cheers for Children event in the fall at the Tallahassee-Leon County Civic Center. There are a group of students at FSU that are pushing the boundaries of human flight. The FSU Skydiving Club at FSU... The Skydiving Club at FSU consists of a tight-knit group of men and women that share an interest in the exhilarating sport. They frequently travel to locations all over Florida to make their jumps. The club invites anyone who is interested to come and join them. They also have a mentor program set up to help newcomers learn the basics of skydiving. Lady Spirit Hunters are a tribe of young, dedicated women, and their goal is to spread Seminole pride. 4FSU reporter Taylor Duran has the story. For scheduled Spirit Hunter events, check out their website. That's all for your sports update. Back to you, Annalise and Cole.
She has a mic, just one up. She has a mic, yeah. She's not wired IFB though. She just needs to.
This is a fun piece right here that we're about to see.
What?
This is a fun little two-shot that we're about to do.
Is it 812?
Thank Sean from cheering. And then it goes straight to you.
Okay. Yeah, it is fun.
Yeah. Well, it's gonna,
So we can smile.
yeah.
Am I reading too slow?
It's
No?
perfect.
Okay.
She looks cute.
She does.
You look really cute. She looks like she's going to do entertainment, you know. And
Yeah, I like the skirt.
Yeah. Budding nightlife.
I know.
I think you should say something else.
Like what?
It's Nowels. There's no K in the beginning.
That's where you want your shoulder to be.
Uh-oh. Thanks, Sean. From cheering on the sidelines to creating friendships at a nightclub.
Seminole Showcase reporter Christy Knowles fills us in on Tallahassee's nightlife.
Thanks, you two. A Tallahassee bar is going above and beyond serving a simple glass of beer, and the public is taking notice. 4FSU's Marissa Elise has the story. For more information on Proof, visit their location on West Tennessee Street between Starbucks and Chick-fil-A. An event that features diverse elements occurs weekly on FSU's campus. 4FSU's Alexis Camarde takes a closer look at what... Sorry about that.
Are you hearing him in your ear?
Not at all.
She's not hearing. All right, please. Keep going, Mike. Mono or stereo? Should be in mono. Oh. It should be plugged in.
Oh. Yeah.
Can you ask if you can hear now?
Okay.
Hello.
Yes. Yes, it was my fault. Or I didn't do it.
Yes. Okay. For more information on Proof, visit their location on West Tennessee Street between Starbucks and Chick-fil-A. An event that features diverse elements occurs weekly on FSU's campus. 4FSU's Alexis Camarda takes a closer look at just what happens every Wednesday at the Union. If you have any questions about Market Wednesdays, call the Student Activity Center at 850-644-6673. Okay. Okay. If you have any questions about Market Wednesdays, call the Student Activity Center at 850-644-6673. Electronic dance music has taken over America's dance floors. 4FSU's Kristen Cervone takes a look at how the musical genre is impacting the students and the community. Cervone, okay, sorry. Okay. If you have any questions about Market Wednesdays, call the Student Activity Center at 850-644-6673. Electronic dance music has taken over America's dance floors. Sorry. Floors? Yeah, okay. Okay. If you have any questions about Market Wednesdays, call the Student Activity Center at 850-644-6673. Electronic dance music has taken over America's dance floors. 4FSU's Kristen Cervone takes a look at how the musical genre is impacting the students and the community. You can sign up for EDM at FSU at Market Wednesdays on campus, or you can visit the group's Facebook page, facebook.com/groups/EDM at FSU. That's all for I don't know why I said that like that. I know. Okay. You can sign up for EDM at FSU. It's all for entertainment. Back to you, Cole and Elise.